I have spent decades listening to arguments inside a courtroom. Some people come seeking justice, some come seeking money, some come seeking revenge. And then there are people like Karen. People who believe the loudest voice automatically wins. People who confuse interruption with intelligence. People who think if they keep talking long enough, nobody else will notice they have no evidence. I remember the day Karen entered my courtroom because from the very first minute she would not stop interrupting, not the plaintiff, not the witnesses, not even me. And what she did not realize was that every interruption was leading her closer to a response she would never forget. A response so devastating that the entire courtroom went silent, including Karen. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you have not subscribed yet, subscribe now. Also, comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. The plaintiff was a woman named Rebecca Turner, 34 years old. Elementary school teacher, soft-spoken, organized, the kind of person who carefully stacked her documents before sitting down. Across from her sat Karen Mitchell, 41 years old. Expensively dressed, perfect hair, dot-dar handbag, and an expression that suggested she had already decided how the case would end. Years on the bench teach you to pay attention before people start talking. Body language often introduces a person before words do. Rebecca looked nervous. Karen looked offended. That distinction mattered. Nervous people usually understand they are entering a serious environment. Offended people often believe the environment should adapt to them. The dispute involved $22,000. Rebecca claimed Karen had hired her husband's landscaping company to completely redesign the outdoor area of her luxury property. The work was completed. The invoices were approved. Then Karen refused to pay the final balance. Sybil, enough. At least that is what I thought. The moment I asked Rebecca to begin speaking, Karen interrupted immediately. She's lying. Those were her first words, not a greeting, not an explanation, not an argument. She's lying. I raised my hand. Ms. Mitchell, you will have an opportunity to speak. She always does this. Ms. Mitchell, she twists everything. Ms. Mitchell, stop talking. The courtroom became silent. Karen leaned back in her chair, not embarrassed, annoyed. That caught my attention. Most people become cautious after a direct warning from the bench. Karen looked irritated that I had interrupted her interruption. Rebecca began explaining the project. She described the design consultations, the signed agreements, the installation process, the completed inspections, the approved invoices. Everything was orderly, logical, escorted by documents. And every 30 seconds, Karen interrupted again. That's not true. She's leaving things out. That's misleading. She knows exactly what happened. Over and over, again and again. At first, the interruptions seemed impulsive. Then I noticed something. They were strategic. Karen did not interrupt random details. She interrupted specific facts, the strongest facts, the documented facts. Interesting, very interesting. Years of courtroom experience teach you that some people interrupt because they are emotional. Others interrupt because they are afraid. The second category is usually more revealing. I continued listening. Rebecca presented photographs of the completed landscaping project. The images appeared impressive. Stone pathways, custom lighting, retaining walls, decorative gardens. Everything looked professionally completed. I asked a simple question. Ms. Mitchell, did the work shown in these photographs occur on your property? Before Rebecca could answer, Karen interrupted again. Yes, but that's not the point. There it was, another important clue. She had just confirmed the work existed without realizing it. Sometimes the truth escapes before a person notices. I looked toward her. The question was not whether it was the point. Karen sighed dramatically. The point is that the work was terrible. Specifically, everything. That answer immediately raised my suspicions. People telling the truth usually provide details. People avoiding the truth usually provide generalizations. Everything. Nothing. Always. Never those words appear often when evidence is weak. What specifically was terrible? I asked. Karen crossed her arms. The whole project. Be specific. The design. What part of the design? The landscaping. Several spectators exchanged glances. I noticed Karen was talking, but she wasn't actually answering, and every time I requested specifics, she interrupted before anyone else could speak. Then Rebecca produced something interesting, a folder containing text messages. The moment Karen saw it, her confidence shifted, only slightly. But enough. I noticed her eyes immediately lock onto the folder. That reaction told me those messages mattered. Rebecca handed them to the clerk. I began reading. The first several messages were routine. Project updates, scheduling material approvals. Then I found one sent by Karen herself. I read it silently, then again, then a third time, because it directly contradicted everything she had been saying. So I looked up Ms. Mitchell. What? Did you send this message? Karen hesitated, just briefly. Yes, I read it aloud. The backyard looks absolutely amazing. I can't stop showing it to people. The courtroom became quiet. Rebecca said nothing. Karen immediately leaned forward. That's out of context. Interesting. Very interesting, because she had not denied sending it. She had not denied writing it. She had not denied praising the project. She only claimed it was out of context. I asked her to explain the context. Instead of answering, she interrupted again. She knows exactly what I meant. Mrs. Mitchell. She's manipulating this as Ms. Mitchell. She always. Stop. Silence. Karen glared at me, actually glared. And that was when I realized something important. Karen was not trying to win through evidence. She was trying to win through volume. The louder she became, the weaker her evidence appeared. Then I found another message, and another, and another. Each one praising the project, each one written by Karen, each one making her position more difficult to defend. The spectators noticed too. You could feel the mood shifting. Karen sensed it. Her interruptions became faster, more frequent, more desperate. Then she made a mistake. A very serious mistake. I asked Rebecca a question about payment records. Before Rebecca could answer, Karen stood up, actually stood up, pointed across the courtroom, and began speaking over both of us. At the same time, the courtroom froze. And I remember thinking one thing: Karen had no idea what was about to happen next. Karen stood in the middle of my courtroom, pointing directly at Rebecca Turner. Not speaking, shouting. There is a difference. Speaking is intended to communicate. Shouting is often intended to control. And Karen had spent the entire morning trying to control the room, control the conversation, control the narrative, control the pace, control the facts. Now she was attempting to control the courtroom itself. That almost never ends well. Sit down, I said. Karen continued talking. Actually, she talked louder. Rebecca remained silent. The spectators remained silent. Even the court officers remained silent. Everyone was waiting, not for Karen, for me. Years on the bench teach you that authority is not established through volume. It is established through consistency. If a judge allows one person to dominate the process, the courtroom stops functioning. Ms. Mitchell. Karen kept talking. Ms. Mitchell. Still talking. Sit down. Nothing. I watched her carefully. Most people stop after the second warning. Some stop after the third. Karen appeared convinced the rules applied to everyone except herself. Finally, A court officer took one step forward. That got her attention. Immediately, Karen stopped speaking, not because she respected the instruction, because she noticed consequences approaching. Interesting. Very interesting. She slowly sat down, then crossed her arms. Agony. That had become a pattern. Whenever Karen felt cornered, she crossed her arms as though physically protecting herself from facts. I returned my attention to Rebecca. Please continue. Rebecca nodded, then presented the payment records. Everything appeared straightforward. Deposit received, progress payments received. Final payment outstanding, $22,000. Nothing unusual until I noticed something handwritten on one of the invoices. A note, small, easy to miss. I read it twice, then looked up. Ms. Mitchell. Karen immediately interrupted. What now? The courtroom reacted. Several spectators visibly sighed. Even Rebecca looked exhausted. Karen simply could not stop herself. Did you write this note? What note? I held up the invoice. The note read, hold final payment until appraisal complete. Interesting, very interesting, because until that moment, Karen claimed she refused payment due to poor workmanship. This note suggested a completely different reason. Explain this. Karen hesitated. Then she said something that caught my attention. That doesn't matter. Whenever evidence suddenly doesn't matter, it usually matters a great deal. I asked again. What appraisal? Karen shifted in her chair. The property appraisal. Why delay payment for an appraisal? It was just a precaution. A precaution. Interesting answer. Not a convincing answer, but interesting. Rebecca immediately produced another document. A property valuation report. The date matched the invoice. I reviewed it carefully. Then something clicked. The landscaping project had increased the property's market value substantially, far more than the cost of the work itself. I looked toward Rebecca. When was this appraisal completed? 1 week after the project ended. And Karen received a copy? Yes. Now I understood. Or at least I thought I did. The project improved the property, the value increased, Karen knew it, yet she still refused payment. That contradiction bothered me. Because contradictions often hide motives, I turned toward Karen. Did the project increase the property's value? Yes. She answered before thinking. The moment she did, she regretted it. I could see it. A flash of panic, gone almost instantly, but not fast enough, because now we had another problem for Karen. The project was supposedly terrible, yet it increased property value. And she knew it. The spectators were noticing the same thing. The room felt different, less uncertain, more focused. Karen felt it too. That was when the interruptions became even worse. Every question triggered an interruption. Every answer triggered an interruption. Every document triggered an interruption. At one point, she interrupted herself. I am not exaggerating. She began answering a question, then interrupted her own answer to start a different argument. The spectators actually laughed. Briefly, Karen immediately turned toward them. What's so funny? That question made things worse, much worse, because now the courtroom could see exactly how frustrated she had become. Frustration is dangerous, especially for people who depend on appearing in control. The more frustrated Karen became, the more control she lost. Then Rebecca presented the evidence Karen clearly feared most, AMs, hundreds of them, organized by date, organized by topic. Organized perfectly. The moment Karen saw the stack, her confidence dropped again. I noticed immediately, because people react differently to different evidence. Some fear photographs. Some fear witnesses. Karen feared records. That told me something. Records are objective. Records don't get emotional. Records don't forget. Records don't exaggerate. They simply exist. I began reviewing them. The first few were ordinary. Then I found something, a message from Karen to a real estate broker sent privately 3 days before she refused payment. Interesting timing. Very interesting timing. I read silently, then again, then a third time, because I wanted to make sure I understood exactly what I was seeing. I looked toward Karen. She immediately knew. The reaction was instant. Her eyes widened, her shoulders tightened, and for the first time all day, she did not interrupt. That caught my attention, because silence from Karen had become unusual. I held up the email. "Did you send this?" "No answer, Mitchell." Still no answer. Then finally, "Yes." The courtroom became silent. I read the email aloud. "If I can delay paying the landscaping contractor for another 60 days, my cash flow problem disappears." Nobody moved. Nobody. They spoke. Even Karen remained silent, because there it was, the truth. Simple, direct, documented. The issue was never poor workmanship. The issue was money. Specifically, Karen's money. She had a cash flow problem, and instead of admitting it, she created a dispute. Suddenly, everything made sense. The complaints, the delays, the excuses, the interruptions, everything. Rebecca closed her eyes, almost as though months of frustration had finally been validated. Karen looked trapped, because she was, not by opinions, not by accusations, by her own words. Then something happened that completely changed the direction of the case. The court clerk approached my bench carrying a document that had just arrived electronically. I glanced at it. Then I looked again, because what I was reading did not seem connected to landscaping at all, at least not initially. The document referenced Karen Mitchell, a pending civil action, multiple plaintiffs, and allegations I was not expecting. I slowly looked up. Karen saw the document, and the color disappeared from her face. Immediately, not annoyance, not frustration, fear, pure fear. I looked directly at her. "Ms. Mitchell." She said nothing. "Would you like to explain why 8 other contractors are suing you right now?" The question hung in the air. Would you like to explain why 8 other contractors are suing you right now? Karen did not answer. For the first time since entering my courtroom, Karen Mitchell had nothing to say. And believe me, that alone was remarkable. This was a woman who had interrupted witnesses, interrupted evidence, interrupted questions, and at least twice interrupted herself. Now she sat completely silent. The courtroom noticed. I noticed. Most importantly, Karen noticed, because people who rely on controlling conversations become deeply uncomfortable when silence arrives. Silence leaves room for facts. And facts were beginning to pile up around her. I looked down at the document again. The filing had been submitted only days earlier. 8 plaintiffs, 8 separate businesses, different services, different projects, different locations. Yet the allegations sounded disturbingly familiar. Compete work, approved work, delayed payment, excuses, disputes, refusal. Interesting, very interesting. Patterns matter. 1 dispute can be bad luck. 2 disputes can be coincidence. 8 disputes begin to look like a business strategy. Say, I turned toward Karen. "Are these lawsuits real?" She finally spoke. "They're frivolous." That answer immediately caught my attention, because she did not deny the lawsuits existed. She only criticized them, a subtle but important difference. "Did you hire those businesses?" "Yes." "Did you pay them?" "It's complicated." Interesting, the answer had changed. A few minutes earlier, Karen spoke with certainty about everything. Now, certainty was disappearing. When people move from clear answers to vague answers, there is usually a reason, and that reason is rarely helpful to their case. I reviewed the filing more carefully. 1 contractor alleged non-payment. Another alleged fraudulent misrepresentation. Another claimed Karen intentionally delayed final approval to avoid payment deadlines. The details varied. The pattern remained. Rebecca looked stunned. Apparently, she had never seen this filing either. That surprised me, because even Robert Hayes from the previous case had discovered similar patterns through investigation. Rebecca had simply believed she was dealing with one difficult customer. Now she was discovering she might be part of something larger. Karen sensed the shift in the room. The spectators were no longer evaluating whether Rebecca deserved $22,000. They were evaluating Karen herself. That is a dangerous transition for any defendant, especially one who relies on credibility, and Karen's credibility was deteriorating rapidly. I continued reading. Then I found something unexpected, a sworn statement from one of the other contractors, a roofing company owner named Daniel Brooks. His testimony immediately caught my attention. According to Daniel, Karen repeatedly praised his work throughout the project. She approved completion, recommended him to others, thanked him publicly, then refused final payment. The story sounded familiar, very familiar. In fact, it sounded almost identical to Rebecca's experience. I looked toward Karen. "Did you tell Mr. Brooks his work was excellent?" She hesitated. "Yes." "Then why refuse payment?" "The work had problems." "What problems?" Karen opened her mouth, then stopped because she had already encountered this problem earlier. Specifics are difficult when the truth is weak. The courtroom waited. Karen searched for an answer. Nothing came. That silence spoke volumes. Then I found another statement, and another, and another. Each one sounded strangely familiar. Praise, approval, completion, then conflict, then non-payment. The same sequence repeated over and over. Like a script, that observation disturbed me because patterns that consistent are rarely accidental. I looked toward the spectators. Several were shaking their heads. Others exchanged looks. Even the court officers appeared skeptical. Karen saw it too. That was when her interruptions returned. Suddenly, aggressively, desperately. "This is irrelevant. Those people are lying. They're all working together. None of this proves anything." Over and over, again and again. The interruptions came faster than before. Years on the bench teach you something important. When evidence strengthens, liars often speak more, not less, because they believe quantity can compensate for quality. Karen was attempting exactly that. The harder the evidence pushed, the louder she became. Then I found the document that changed everything. A private email, not to a contractor, not to a broker, not to a lawyer, to her personal financial advisor. The subject line immediately caught my attention: cash management strategy. Interesting. Very interesting. I opened the email. Karen saw it and instantly stopped talking. That reaction alone told me the document mattered. I began reading. The email discussed short-term liquidity issues, investment obligations, upcoming debt payments, and then a sentence that made the entire case suddenly make sense. I read it twice, then a third time. Just to be certain, the spectators waited. Karen stared at the table. I looked up. "M. Mitchell." No answer. "Did you write this email?" A pause, then, "Yes." The room became silent. I read the sentence aloud. "The easiest financing source right now is delaying vendors until after the refinance closes." Nobody moved. Nobody spoke. Rebecca slowly lowered her head because suddenly everything became clear. The landscaping dispute had never been about landscaping. The complaints had never been about quality. The invoices had never been the real issue. Karen was using contractors as lenders, unwilling lenders, instead of obtaining financing honestly. She delayed payment, held money, cry-eyed disputes, bought time, and hoped businesses would survive long enough for her financial problems to disappear. The courtroom felt different now, not emotional, analytical. People could finally see the mechanism, the strategy. The motive, Karen sensed it too. And that terrified her, because once people understand the motive, the excuses become much weaker. Then she made a mistake, a huge mistake. One that would eventually lead to the brutal response she would never recover from. She interrupted me again, not once, not twice, 3 times in less than 10 seconds. I warned her. She interrupted again. I warned her again. She interrupted again. The spectators could hardly believe what they were watching. Neither could I, because by that point, Karen was not merely interrupting out of habit. She was interrupting because she was losing control, and losing control frightened her. Then she leaned forward, pointed toward me, and said something that made the entire courtroom freeze, something so arrogant, so disrespectful, that even after decades on the bench, I could hardly believe I had heard it. And the moment those words left her mouth, I knew exactly what I was going to say next. The courtroom became silent, not ordinary courtroom silence. The kind of silence that arrives when everyone realizes a line has just been crossed. Karen leaned forward across her table. Her face was red with frustration. Her composure was gone. The carefully controlled image she brought into court that morning had completely fallen apart. And then she said it. You keep acting like you're smarter than everyone else. The spectators froze. Karen continued. You sit up there and talk while real people actually build things, run businesses, and solve problems. I watched her carefully. Years on the bench teach you something important. The most revealing statements are often made during emotional collapse, because that is when people stop managing their image. They stop calculating, they stop pretending, and they start revealing exactly what they believe. Karen was revealing herself, one sentence at a time. You have no idea what it takes to manage money. The courtroom remained silent. You have no idea how business works. Still silent. So you just sit there judging people. Interesting, very interesting, because Karen had accidentally revealed something important. She genuinely believed accountability was unfair, not because she was innocent, because she considered herself too important for it. I let her finish. That surprised her. She expected interruption. She expected an argument. She expected conflict. Instead, I simply listened, and the longer she talked, the worse things became. Then she made another mistake, a fatal one. She pointed toward Rebecca. People like her don't understand business. Rebecca lowered her eyes. Karen pointed toward the spectators. They don't understand business either. Several spectators exchanged looks. Karen kept going. At this point, she was no longer defending herself. She was attacking everyone. Then she pointed toward me and delivered the sentence that would ultimately destroy her. You work for people like me. The courtroom froze. Completely, absolutely frozen. I remember looking around the room. Nobody moved. Nobody spoke. Nobody even seemed to breathe. Karen apparently thought she had scored a point. The faintest smile appeared on her face, and that's when I realized something. Karen genuinely believed status determined value. The wealthy mattered, the powerful mattered, everyone else existed somewhere below them. That belief explained everything: the unpaid contractors, the delays, the manipulation, the lawsuits, the interruptions, everything. Because once you stop seeing people as equals, treating them unfairly becomes much easier. I looked directly at Karen. Then I looked at the stack of evidence, then back at Karen, and I finally spoke calmly, very calmly, because some responses become more powerful when they arrive quietly. Ems Mitchell. Karen folded her arms. What? I paused. The room waited. Then I said, no. Karen blinked. Confused, I continued. I do not work for people like you. The courtroom remained silent. Karen's smile disappeared. You misunderstand something very important. I leaned slightly forward. You think money creates authority. Karen said nothing. You think success excuses behavior. Still nothing. You think wealth places you above the people who build your houses, maintain your property, teach your children, and follow through on agreements. The spectators remained completely silent. Nobody wanted to miss a single word. Those people are not beneath you. Karen's face tightened. I continued. You hired Rebecca's company because you needed their expertise. Silence. You hired contractors because you needed their skills. Silence. You signed agreements because you needed their work. Silence. Yet somehow you convinced yourself that needing people made you superior to them. I remember seeing several spectators nod. Even Rebecca looked shocked. Karen tried to interrupt. Agin. That's not. I raised one finger. She stopped for perhaps the first time all day, because now she understood something. The room was no longer reacting to her. The room was listening carefully, and she could not stop it. Then I delivered the statement that would spread far beyond that courtroom, the statement people would discuss long after the case ended. Mitchell, if 8 contractors, dozens of emails, signed approvals, payment records, appraisal reports, and your own financial messages all point in the same direction. I paused. Karen stared at me. The spectators stared at me. Everyone waited. Then I finished. The problem is not that everyone else is wrong. The room remained silent. The problem is that you finally found a room where interrupting people cannot change the truth. Absolute silence. Total silence. Karen looked stunned, actually stunned, because the statement had done something no evidence managed to do. It removed her strategy completely, every interruption, every distraction, every excuse, every attack, all reduced to a single reality. Facts remained facts. No matter how loudly she spoke, I could see the realization arriving slowly, painfully, publicly. And that was when something unexpected happened. Karen stopped interrupting entirely. Not for 10 seconds, not for 30 seconds. Completely, for the first time all day, she had nothing to say. The spectators noticed, Rebecca noticed, the officers noticed, and honestly, the silence was remarkable, but the case wasn't over. Not even close, because moments later, new evidence would arrive, evidence so devastating that even Karen's complete silence would not save her. And when it appeared, the entire courtroom would understand why she had been fighting so desperately from the beginning. For the first time that day, Karen Mitchell sat completely silent, no interruptions, no arguments, no dramatic sighs, no sarcastic comments, nothing. And honestly, that silence was more revealing than everything she had said during the previous 2 hours, because people like Karen depend on momentum. They depend on noise. They depend on keeping everyone else off balance. The moment they lose that ability, the situation becomes dangerous for them, very dangerous. I remember looking at her and thinking something unusual. She was finally listening, not because she wanted to, because she had run out of places to hide. The courtroom remained quiet. Rebecca sat motionless. The spectators watched carefully. The officers stood near the walls. Everyone sensed the same thing. The case was approaching something important. Then the court clerk approached my bench. She carried a newly received document package. I accepted it, reviewed the first page, then the second, then the third, and immediately understood why Karen's attorney had gone pale. Interesting, very interesting. I looked toward Karen. Her silence vanished, not through interruption, through fear. The kind of fear people experience when they recognize a document before anyone else does. Mems Mitchell. She didn't answer. Have you ever heard of Northridge Lending Group? Her eyes widened. That was answer enough. The spectators exchanged looks. Rebecca appeared confused. I understood why Northridge had never been mentioned before, at least not publicly. But the documents in front of me connected Northridge directly to Karen's financial difficulties, and more importantly, to her motive. I reviewed several pages loan agreements, debt obligations, refinancing deadlines, proprietary leverage reports. Then I found the key detail, the detail that changed everything. Karen had been facing a financial deadline, a major one. A deadline occurring less than 2 weeks after Rebecca's project was completed. Interesting timing, very interesting timing, because suddenly all the pieces aligned perfectly, the delayed payments. The contractor disputes, the excuses, the interruptions, the cash flow problems. Everything pointed toward one conclusion: Karen needed money desperately, and delaying contractors bought her time. I looked toward Rebecca. Did Miss Mitchell ever mention refinancing? Rebecca nodded immediately. Yes. When? Several times during the final month. The courtroom became quiet again. I continued reviewing the records. Then I found something even more damaging. An internal email, private, confidential, never intended for a courtroom. Those are often the most dangerous documents, because people tend to tell the truth when they believe nobody important will ever read it. Karen clearly believed nobody would. She was wrong. I looked toward her. Did you write this email? Karen closed her eyes. That reaction alone told me everything. Miss Mitchell, a long pause then. Yes. The spectators leaned forward. I began reading. Delay Turner Landscaping until after refinancing closes. If necessary, create performance concerns. Nobody moved. Nobody spoke. The courtroom felt frozen. I continued. Most small businesses cannot afford prolonged litigation. Rebecca slowly lowered her head. The room remained silent. Then came the sentence that changed everything. The sentence that transformed suspicion into certainty. I read it slowly, word for word. By the time they prove they're right, I'll already have what I need. Silence, dot-spittle silence. Karen stared at the table. Rebecca covered her mouth. Even the court officers looked stunned, because now the motive was documented, not implied, not suspected, documented. Karen had planned it. Not necessarily years in advance, but intentionally, deliberately, strategically. The landscaping dispute had been manufactured. Crete designed. Rebecca was never supposed to win quickly. Karen only needed delay. And delay was exactly what she attempted to create. The spectators understood it immediately. So did Rebecca. You could see it on her face. Months of confusion suddenly became clarity. One of the most painful experiences a person can endure is wondering whether they are being treated unfairly. The second most painful is discovering they were right all along. I looked toward Karen, still silent, still staring downward. Then something unexpected happened. Rebecca stood, not emotionally, not dramatically, calmly. I allowed her to speak. She looked directly at Karen for several seconds. Then she asked one simple question, a question that changed the emotional atmosphere of the entire room. Did you ever intend to pay us? The courtroom froze. Karen slowly raised her head. Rebecca wasn't angry. That was the surprising part. She wasn't shouting, wasn't accusing, wasn't insulting. She genuinely wanted an answer. Years on the bench teach you that simple questions are often the hardest to answer, especially when the truthful answer creates problems. Karen opened her mouth, closed it, opened it again. Nothing, no explanation, no defense, no excuse, because there wasn't one. The silence became unbearable. Then Karen finally whispered, I needed time, not an answer, a confession. Rebecca nodded slowly, almost sadly, because she had finally received the truth, not justice. Not yet, but truth. And truth matters, sometimes more than people realize. The courtroom remained silent. Then another document caught my attention. One final document. I reviewed it carefully. Then again, then a third time, because what I was seeing was extraordinary, very extraordinary. The document wasn't from Rebecca. It wasn't from Karen. It wasn't from any contractor. It was from Northridge Lending Group itself. And according to the report, someone had already provided investigators with evidence that Karen intentionally misrepresented financial obligations during refinancing. In other words, the contractor payments weren't merely part of a civil dispute anymore. They may have become part of something much larger, something federal. I slowly looked toward Karen. She looked back at me, terrified, truly terrified. And then the courtroom doors opened. A man entered, dark suit, federal credentials, professional expression. The room immediately became silent. He approached the clerk, handed over paperwork, then looked directly toward Karen. I reviewed the documents, and even after everything that had happened, I still remember the shock that moved through the courtroom when I read the first line, because Karen's worst problem was no longer Rebecca Turner. It wasn't the contractors. It wasn't the lawsuit. It wasn't even the money. Karen Mitchell had just become the subject of a federal fraud investigation. And suddenly, every interruption she made that day looked very small compared to what was coming next. The moment I finished reading the paperwork, I looked up at Karen Mitchell. She already knew. Before I said a single word, before anyone explained anything, before the federal representative even took his seat, Karen knew. Because people who build their lives around manipulation often recognize the sound of consequences long before anyone else hears them. The courtroom was silent. Rebecca Turner stared at me. The spectators sat frozen. Even the court officers appeared unusually focused. Everyone sensed the same thing. The case had crossed a line. What began as a dispute over $22,000 had become something much larger, much more serious, and Karen's interruptions could no longer protect her. I placed the documents on my bench, carefully, deliberately. Then I spoke. Miss Mitchell, federal investigators have requested preservation of all records connected to several ongoing financial reviews. Karen lowered her eyes. No interruption, no argument, no sarcastic comment, nothing. That alone was remarkable. Hours earlier, she could not remain silent for 10 seconds. Now she could barely speak at all. Years on the bench teach you something important. People often mistake confidence for strength, but confidence built on deception is fragile, extremely fragile. Once the deception cracks, the confidence usually disappears with it. That is exactly what happened to Karen. The woman who entered my courtroom, convinced she controlled everything, now looked like someone desperately searching for an escape that no longer existed. I reviewed the remaining evidence, the emails, the invoices, the payment records, the refinancing documents, the contractor lawsuits, one by one, piece by piece. Every document pointed in the same direction, not confusion, not misunderstanding, not poor communication, intentional delay, intentional pressure, intentional non-payment. The pattern was impossible to ignore. Rebecca sat quietly, watching, listening, waiting. I remember looking at her and thinking how different she was from Karen. Rebecca spent months gathering evidence. Karen spent months creating excuses. Rebecca prepared facts. Karen prepared interruptions. And in the end, facts proved stronger. They almost always do. I turned toward Rebecca. How many employees work for your husband's company? 12. The answer was immediate. I nodded. 12 families, 12 households, 12 groups of people, depending on honest business transactions. That mattered, because unpaid invoices are rarely just numbers. Behind every invoice are real people, real wages, real responsibilities, real consequences. Karen never seemed to understand that, or perhaps she understood and simply didn't care. Honestly, I'm not sure which possibility is worse. Then I turned toward Karen. Do you have anything further to say? The question hung in the air. The entire courtroom waited. This was her opportunity. One final opportunity to explain, to apologize, to accept responsibility, to show some sign of understanding. Karen looked down at the table. For several seconds, she said nothing. Then finally she spoke, quietly, very quietly. I didn't think it would go this far. Interesting. Very interesting. Not, I was wrong. Not, I'm sorry. Not, I shouldn't have done it. Instead, I didn't think it would go this far. That statement revealed something important. Karen regretted the outcome, not necessarily the behavior. There is a difference, a very important difference. Years of courtroom experience have taught me that true remorse focuses on harm caused to others. Fear focuses on consequences suffered by oneself. Karen still seemed focused on consequences. I listened carefully, she continued. I thought everything would work out. Another revealing statement. People who create problems often assume future success will somehow erase present misconduct. But that is not how accountability works. Future profits do not erase broken agreements. Future opportunities do not erase dishonesty. And future success does not erase the damage done along the way. I issued my ruling. Rebecca Turner prevailed. The evidence was overwhelming. The contract was valid. The work was completed. The payments were owed. Judgment entered in favor of the plaintiff, Sybil. Clear. Escorted by facts, the courtroom remained quiet. Rebecca closed her eyes briefly, not in celebration. In relief, there is a difference. Victory excites people. Relief frees them. Months of uncertainty had finally ended. As for Karen, she barely reacted because by then the civil judgment was no longer her biggest concern. The federal investigation occupied that position. And she knew it. The hearing concluded. People began leaving. Spectators gathered their belongings. Court officers resumed normal duties. The federal representative quietly spoke with attorneys. The ordinary rhythm of the courthouse returned. But I remained seated for a moment, watching, reflecting, because some cases stay with you, not because they are legally complex, because they reveal something about human nature. This case revealed a great deal. Karen believed interruptions created control. She believed speaking louder made her stronger. She believed confidence could replace evidence, and she believed status could replace accountability. Every one of those beliefs failed. Completely, the most memorable moment was not the ruling. It was not the evidence. It was not even the federal investigation. It was that single response that finally stopped her from interrupting, the moment she realized something important. Perhaps for the first time in her life, that the truth does not become weaker because someone talks over it, and that reality does not change simply because a person refuses to listen. Months later, I learned that additional contractors came forward. More records surfaced. More questions were asked. The investigations continued, as they should. Rebecca's company recovered. The employees kept their jobs. The project remained exactly what it had always been: calipined, successful, properly performed. The facts never changed. Only the noise around them did. I have presided over thousands of cases, yet I still remember Karen Mitchell, not because she interrupted everyone, but because she eventually encountered something her interruptions could not overcome. Evidence. And once evidence speaks clearly enough, even the loudest person in the room can become speechless. That day, Karen entered my courtroom believing she could control the conversation. She left understanding a lesson that applies far beyond any courtroom. You can interrupt people. you can delay people, you can talk over people. But sooner or later, the truth gets its turn to speak.